seated. Call now cause numbers PD 052221, 052321, 052421, and 052521. Ex parte Robbie GAIL CHARETTE.
May it please the court. I am Lewis Thomas on behalf of Petitioner Robbie GAIL CHARETTE. This court should reverse the decision of the Court of Appeals and dismiss the indictments in these cases because Petitioner CHARETTE was denied her due process under Government Code 571 and under Texas Constitution Article 1, Section 19. This pretrial habeas is cognizable in this court because the special prosecutor lacked the power to proceed to indictment without a referral for criminal prosecution from the Texas Ethics Commission. The state's theory of this case is that any...
Counsel, what if there's evidence of a violation and the commission, for whatever reason, doesn't make a referral? The prosecution is then never allowed to prosecute?
If a if a complaint is filed with the commission has a statutorily mandated process that they must follow. And there's a list of factors in the government code that they must consider when deciding appropriate sanctions. In this case, none of that occurred. So the answer to your question is yes. And the reason for that is the legislature, along with the voters of this state when they enacted Article 3, Section 24A, was to provide the Ethics Commission with the authority, a nonpartisan commission with authority to decide these type of pre-election matters.
Sure, but doesn't the enforcement statute specifically list 3 different entities that can enforce this?
I'm guessing my question is which particular statute?
305. So the statute says that the commission or the attorney general or the local prosecutors can enforce anything in the chapter.
And I agree that that is exactly what it says in Chapter 305,
Right.
which is very much in favor of our argument. And the reason for that is the only of all of the 571.061 portions of the election code and the government code that the TEC is empowered to enforce, where it is specifically delineated that a district attorney can also enforce that section. Ms. CHARETTE was not charged with Section 305. There's Title 15 of the election code contains except for one of the charges, and then there's Chapter 572. Chapter 305 is not within any of the charges that are present in this case. And so, my argument would be the absence of any other enabling legislation referencing the district attorney points out that the legislature enacted that 305 for a reason, because that's the only one that the legislature saw in its discretion, in its legislative mind, would be appropriate for district attorney to enforce. None of those are present in this case. These are Title 15, which is not Chapter 305. Chapter 305 just pertains to lobbyists. And so that has nothing to do with our case at all. Ms. CHARETTE was not a lobbyist. She was a candidate for a county court of law. And so if you look at the remainder of all the sections that the TEC is statutorily mandated and constitutionally empowered to enforce, that is conspicuously absent. And so that would be, I think that adds to our argument rather than takes away from it.
I've got a question. So it seems to me, and correct me if I'm wrong, please, but it seems to me like your argument is premised on an idea that in the absence of a criminal referral, that somehow that criminal referral for prosecution from the Ethics Commission is a prerequisite to the authority of a prosecutor to seek an indictment or of a grand jury to hand down an indictment. And so if that's true, that's my impression,
Yes.
then what is your sort of strongest authority, statutory or otherwise, for that proposition that a criminal referral is a prerequisite to criminal prosecution?
Chapter 571 says that the commission has the authority to enforce. It also gives the commission certain duties, which some of them may not be delegated, including the referral for criminal prosecution. If you look at the legislative history of what the state had done with these type of ethics laws prior to 1991, you can see that all the way up until 1991, there was specific legislative, if you look at old Chapter 256, which no longer exists in the Election Code, Chapter 256 used to provide that action taken under this chapter does not affect the availability of other procedures for investigation of violations and enforcement of this title. The legislation that was previous to 1987 was even more explicit when talking about sworn complaints, because the Secretary of State at one time for many years, from at least 1973 all the way to 1991, was enabled to review sworn complaints and provide these type of referrals to the prosecution. The older version of that code said, if I can find it, Judge. Nothing in this section shall be taken as precluding the filing of a complaint directly with the prosecuting attorney.
So is your point, though, then, that under the old code, it specifically permitted prosecutors to independently go and prosecute crimes?
Yes.
But under the new code, that language was specifically and intentionally removed. Is that what your point is?
Yes. Yes.
So is there a specific statement in the new code that says you can't do this?
I don't think I can't point to, for example, in the water code, there's not language like in the water code where it says that you have to refer. I think the legislature has lined this out more specifically directly with the TCEQ, like a peace officer can't present these sort of environmental claims unless they first refer it to TCEQ. But my argument is that they've given a statewide agency the authority over all these exact offenses, provided this mountain of process for a person that is only obligated to file these reports because of their participation in an election. And it's simply whether or not a county official decides to send it over here to Austin or to send it directly to, in this case, a special prosecutor. And so a similarly situated defendant in any other place is either allowed a tremendous amount of process or none at all. And so that's the argument, is that statute, and I think it's important for the court to see also in Chapter 571, if a sworn complaint was provided to the Ethics Commission, they are prohibited by law from referring it back to a local prosecutor if it's made within 60 days of the election. The point of the Ethics Commission is to encourage better reporting, and in this case, and not influence the election unduly. In this case, absolutely, that's, I think, arguably what happened is that the announcement of the special prosecutor before an election and then the indictment after the election had an absolute effect on what happened there in Washington County. And so for the legislature to recognize that the existence of a prosecution under these type of statutes was so, I would say, influential to what happens to the election, that they are able to make that determination. And I think the legislature can, into this court's jurisprudence, lay out what is the elements of an offense and what is required before those offenses are prosecutable.
And what's your position if TEC goes the distance and obtains the sanctions that they want? Can the DA then take the case after that process has been completed and prosecute?
Absolutely.
Does that require a referral? Can they just do it unilaterally?
Our position is that it requires a referral, because that is the statutorily mandated process, that they can either resolve the sanctions either informally, formally, or if again, TEC is given a list of factors in Chapter 571 for what's an appropriate sanction, and if they choose to refer it, they can. I think the court, maybe if I'm reading between the questions, is troubled with the fact that the TEC can somehow end a complaint, but I think
I'm
that's...
more curious that if it requires a referral, doesn't the Constitution delegate to district attorneys the authority to prosecute in their own counties?
I completely agree, and I think
And
this court...
does it require permission from any agency to do that?
I think only because of the specific type of offenses at issue here did the legislature make that judgment. And I think the executive branch agency that TEC is able to make those administrative decisions consistent with separation of powers.
Counsel, actually, isn't TEC a legislative branch?
I've reviewed their own filings in many civil matters that are pending against the TEC. They hold themselves out to be an administrative agency, even though it's in Article 3, which is certainly the legislative branch. In their, at least their public filings as of 2021, they, based on the definition of administrative agency, hold themselves out as an executive agency.
Well, counsel, let me make sure I understand kind of your position on TEC's authority versus a DA's authority. So the Texas Constitution provides to the DAs the right to represent the state of Texas in the trial courts. That's what the Constitution says. So in this case, you're not saying that they don't have prosecutorial jurisdiction. You're saying the legislature has said you are not authorized to represent the state of Texas in these types of cases until the TEC gives you that authority to represent the state through a referral process. Is that what you're saying?
Yes.
Okay.
What if it was you've heard of runaway grand juries before?
Of course.
Right. So what if some grand jury in a county, I'm just hypotheticalizing here, some grand jury gets wind that, you know, some person who's a candidate or an elected official is committing crimes, and so they start issuing their own grand jury subpoenas and requiring people to appear, and lo and behold, they hand down an indictment, right? Is that a void indictment?
Under our reading of the statute, it is, because, again, the legislature set out these, it's not any election code crime, and please, my position is limited to only the specific 571.061, the three, A, B, and C, that the Texas Ethics Commission is concerned with. And so, yes, our argument would be absolutely that's a void statute. Under the, again, if I could expand on your hypothetical, if, for example, the Travis County Grand Jury reviewed the campaign finance reports for members of this court or any court in Travis County and observed the lack of a zip code under the campaign finance reports, under the state's theory, that your exact hypothetical could absolutely occur. That all of any judge that had omitted a zip code would be liable under the record-keeping required section of the election code. And so I think, obviously, that's not what was the legislature intended by creating an ethics commission to encourage compliance and resolve these by administrative matters. And I think we pointed out in our brief, there's over 1,500 sworn complaint orders that are on the TEC's website since 1991, and there's no cases reported under any of these code sections, which I think lends evidence to the fact that that's what the legislature intended for the process to be for people in this
We've
situation.
spent a lot of time talking about the referral situation. I'd like you to tell me why this is even cognizable.
Because under the court's statement in Smith and also in Perry, it's a constitutional violation in the sense that it violates Ms. Charette's due process. She didn't have the opportunity, neither the notice or the opportunity to resolve these complaints administratively prior to indictment. The court has said that a pretrial habeas is cognizable if the trial court lacks power to proceed. And so based on that due process constitutional violation, that deprived the trial court of jurisdiction at that time.
Counsel, it wouldn't be the trial court's jurisdiction necessarily, it would be the right of the DA to initiate any sort of criminal prosecution without referral. So that they're not allowed to represent the state of Texas, essentially. Wouldn't that be the issue? That they can't even bring these cases? They don't have the authority by the legislature to bring these cases until there's a referral?
I don't disagree with that. I guess my point is that if there's not an adverse party, I don't know how you have I'm not sure if there's a constitutional case where there's not two parties that are able to represent, to be adverse at the trial court. So, yes, I think it is an authority question, and if the court lacks a constitutional case at that moment, then they're also lacking jurisdiction because there's no controversy, no meaningful controversy before the court. I see that the red light has expired. Thank you.
Thank you.
May it please the court and counsel. My name is Brandy Robinson. I'm an assistant district attorney in Austin County, Texas, but I'm representing the Washington County Attorney's Office as a county attorney pro tem today. And less than a year ago, this court decided Stevens, and the majority opinion warned against the dangers of reading vague language or vague law as conveying prosecutorial power away from the judiciary branch and over to the executive branch. And the court posited at that time what the court kind of considered a possible extreme example or unlikely example of what if somebody comes in and says that the legislature has given prosecutorial power over to the Water Advisory Board. And I think both the majority and the dissent thought, well, that's really unlikely that somebody's going to do something like that.
Counsel, with all due respect, this isn't an issue of taking away prosecutorial power from the DA's office. It seems to me this is an issue of the legislature having the ability to say, district attorneys, we do not give you permission to represent the state of Texas in these specific types of cases until there's a referral. So it's a different scenario. It has to do with the authority to represent the state of Texas, not the prosecutorial authority.
That's an area that petitioner's brief really muddies the waters on, because one issue would be cognizable potentially if they've established a legal basis, and one would not. And that's the difference between jurisdiction, prosecutorial jurisdiction to prosecute a case versus limiting prosecutorial discretion to prosecute a case. And here, a prosecutorial jurisdiction in Stevens, the court was examining a jurisdictional element, which if the court found that the prosecutor didn't have jurisdiction, then the prosecutor would not have the right to make the case. It's a void prosecution on its face. And so the court has an interest in examining those in a pretrial habeas writ because it's void on its face. A due process right, a restriction on our discretion to prosecute or initiate prosecution, which is what the petitioner is arguing for here today, typically is not going to be cognizable in a pretrial habeas writ. A due process right, especially one like petitioner alleges here, which would require factual determination of the issues. Petitioner's essentially attacking the sufficiency of the evidence of the charge. That's a due process attack. And a due process attack is not cognizable in a pretrial writ of habeas corpus.
Well, if a criminal referral is indeed a prerequisite to a criminal prosecution, then the absence of a criminal referral should preclude a prosecution, right? And I think one of the things that the court mentioned in the Perry opinion was that it makes for cognizability purposes, makes a big difference if a person has a right to avoid trial. And so what would be your response to that in terms of the cognizability issue?
Certainly. I would say if they are arguing that we lack prosecutorial jurisdiction, period, then that would be a right to avoid trial, which is what was considered there. But they're not arguing. In fact, they have conceded that we have jurisdiction to prosecute election crimes in Washington County, and that the Washington County Court has jurisdiction over the petitioner. Their argument, though, is that she also was entitled to this due process right that would be through the Texas Ethics Commission, which is normally administered in civil proceedings. So they're arguing she's entitled to additional due process rights added to the standard criminal justice scheme, and that she's harmed by that because if the TEC had looked at her case, they would have decided not to review her case. And that's a due process argument that requires speculation on the facts and the evidence. The best evidence we have, you know, the petitioner has brought up again in oral argument, hey, there's all these referrals that happen, or all these complaints that the TEC reviews, and they haven't referred these complaints to prosecutors. That's a factual sufficiency argument when you get down to it. It's trying to argue, look, the state is prosecuting on an indictment where the evidence is going to be insufficient. And in a factual sufficiency case has long been held not to be appropriate in a pretrial writ of habeas corpus because the state can't respond with the facts. We can't provide the evidence that's most important to show that we have a sufficient basis to make the case, to show that even if she were entitled to a referral, that it's moot because of overwhelming evidence against her, for example. It requires specific evidence in the case to be borne out,
But
and then
forgive
she
me,
would have a
because that's not how I
post-conviction remedy.
understand the defense's argument here. I understand the defense's argument to be that if you don't have a criminal referral, no one is permitted to prosecute. And if there's no permissible prosecution, then doesn't that preclude a prosecution? That's how I understand their argument, and I don't know that you're answering that. I mean, maybe your answer is, it is permissible for us to prosecute even in the absence of a criminal referral, and that would change the dynamics, right? But their point, I think, and I may be, you know, I'm trying to understand it as best I can, is that without a criminal referral, there is no permissible prosecution, even if you have prosecutorial authority in the general sense.
We absolutely are arguing that we have the right to prosecute whether we get a referral or not.
Well, then how does that give, then how can we possibly ever give effect to Texas Government Code 571? I mean, because that is, you know, that would be completely disparate treatment among people who are referred through the TEC for the exact same violations, who then have an opportunity for confidentiality, have the opportunity for this administrative process, have the opportunity for appeal and review by the courts of any decisions that are made, have the ability to, if they are victorious and the claims brought against them were found to be frivolous, can get attorney's fees and costs from the complainant. Whereas that can, how can we give effect to that if it can be completely bypassed simply by confidentially reporting to a DA's office that, hey, they violated campaign finance rules and campaign reporting rules, and so you should go prosecute them. And then they're criminally prosecuted with no recourse that is provided for by the legislature in Chapter 571.
Our argument is that if the legislature wants those additional protections to apply to criminal prosecutions, the legislature needs to write a statute that actually says those protections apply, because
It
none of
does. It
petitioners.
says that, and that's where the referral comes in. It can't be prosecuted unless the TEC goes through its process and then refers it to and gives authority and permission to the DA to represent the state of Texas in the trial courts.
Respectfully, on 571.171, which is the one that talks about referral, there is nothing in that statute that says the prosecutor can't prosecute unless they get a referral. There's nothing in the statute that says a decision not to refer is binding on the prosecutor's office. And that absence is important, because the absence of that language, the best case scenario that a petitioner can get from the TEC would be an affirmative opinion saying you did nothing wrong. And the legislature said the consequence when the petitioner gets that best-case scenario opinion is a defense to criminal prosecution.
What
A
is
lack of referral, sorry, the legislative silence on the lack of referral, the petitioner is arguing that would not only constitute a defense, that would constitute an absolute bar to prosecution. So they're arguing that a lower, less favorable decision from the TEC would give them more relief than what the legislature has expressly spelled out. And that's inconsistent interpretation. The petitioner's kind of conjuring this bar out of nowhere. There's no language that says
Well,
it.
what is your response to the argument from appellant's counsel that under a former iteration of these laws, there was a specific grant of authority to prosecutorial agencies to go forward with a prosecution even in the absence of administrative remedies imposed by the agency? And that now, when they created the new iteration of the law, they seem to have removed that former affirmative grant of authority.
I would say that the legislature knows how to limit that authority, and it did when it came to TEC opinions. And it said, this is the legal impact on prosecutors when we render an opinion in a candidate's favor. This is a defense to prosecution, and the petitioner can raise it. If the legislature intended to create a bar to prosecution, then the legislature could have put it. But instead, there's absolutely silence on that issue. There's no bar anywhere in the text of any of the provisions the petitioner has raised.
What about appellant's position that in Chapter 305 that it spells out that there's essentially concurrent jurisdiction to move forward with prosecution against lobbyists in that provision, whereas that is absent in the other provisions?
I would say that we have constitutional and statutory authority under Code of Criminal Procedure 2.07 and under the Constitution, Article 5, Section 21, that gives us the right to prosecute election crimes.
You have the authority to represent the state of Texas for those in the trial courts.
Correct.
But the legislature has the ability to restrict where you can represent the state of Texas, and in like what situations you can represent the state of Texas. The legislature has that, and they seem to have put it in Chapter 571 and by the constitutional amendment to add the TEC to the Texas Constitution.
I would say that there's danger in saying that silence on the issue equals a grant of exclusive prosecutorial authority to the executive branch of government, which is what the opinion in Stevens stood for.
But again, how do we give effect to Chapter 571 if the DA's office can just sidestep the whole chapter?
571 only applies to the civil administrative proceedings that the enforcement provision is there to address. There's nothing that defines enforcement as including prosecutorial jurisdiction. And that's one of the key issues here, is that enforcement is never defined anywhere in those statutes. It's certainly never defined to include prosecutorial jurisdiction. So if a candidate is going through the civil process, the complaint process, because the TEC has gotten a complaint, then they are entitled to TEC review. If they are going through a criminal process from prosecution, then they're entitled to all the due process rights that they're afforded through the criminal courts.
Separate cases in different realms.
Exactly. They're two kind of concurrent but entirely independent penalties. And so the Ethics Commission has these particular rules on how they can seek their penalties, which are all administrative. All the context in the statutes in 571, it's all talking about administrative penalties, the ability to impose fines, to impose cease and desist orders, to enter into civil settlements. There is absolutely nothing in there about criminal prosecution. And when we talk about the separation of powers issue, why it's dangerous to read that silence is because taking away our decision-making authority to prosecute a case goes to the very heart of what a prosecutor does.
What is the purpose of a referral? I mean, after all, anybody who has any information about the possible commission of a crime has the right to call the police department, the sheriff's department, go down to the DA's office and try to get an audience with the elected prosecutor and tell that person hey, I think a crime's been committed and here's what I know about it. And so, but at the same time, the legislature has these provisions that specifically give the power to agencies from time to time to create something called, they may refer for criminal prosecution. So they give the discretion to refer for criminal prosecution. Why would they even write such a law?
Well, I think it
You know,
goes,
I'm curious what your thoughts are.
I think it goes to the definition, the plain language definition, because again, referral in this case is not defined, but the plain language definition is to transfer a matter to another agency for decision. And since the TEC has no independent prosecutorial authority, if they come across a case, let's say a candidate asks for an opinion and says, hey, I've been stealing all the election signs from my opposing candidate. Is this okay? Can I do this? Well, they need a process in place that tells the TEC this is how you handle that. If you've got a crime in front of you, you need to refer it to people that are actually authorized by the Constitution to prosecute that crime. And we need that provision so that the TEC knows what to do in those situations, and that's why it's important.
Well, counsel, the legislature has dictated in Chapter 571 that the purpose of Chapter 571, and by extension the TEC, is to regulate elections and prohibit undue influence. And so the statutes must be construed to eliminate opportunities for undue influence over elections and governmental actions and to ensure the public's confidence and trust in its government. So if the whole purpose is to avoid undue influence, then, you know, and it has provisions saying you can't issue decisions within 30 days of an election, you know, you have to keep matters confidential until, you know, these situations happen, then by allowing the DA to unilaterally jump in there and prosecute and then create undue influence in an election, that completely guts the whole purpose of the TEC in Chapter 571.
I think that criminal prosecution has different rules. What we have are the Code of Criminal Procedure, and those are the rules that tell us how and when we can prosecute cases. And that's what we are bound by. And so we're bound by the examining trial. We're bound by the grand jury. We're bound by going to trial and presenting the evidence and having to have enough evidence to think that we can prove a case.
And you're bound by the authority issued to you by the legislature to represent the state of Texas, right?
Correct. And if the legislature decides to tell the state that the state in all election crimes has to keep it secret until after the election is over and can't initiate a prosecution, and there's an express statute we can look to say that, then I think that we would be bound to keep it secret or to potentially to delay a prosecution. But even if they put that restriction on us, again, you're risking the idea that the legislature is imposing a burden on us that significantly restricts district and county attorneys' authority to prosecute,
And
which
if that
we're
were
given in the
true,
Constitution.
how would that support the concept of having the public have confidence in the elections?
Well, and we're also,
If the matters are serious enough to require some oversight by prosecution.
I think that hit on a very important distinction there, which is that the Texas Ethics Commission is there to handle civil matters. The plain meaning of the language enforce is to get people to comply with the law, to try to compel obedience or give effect to the law. And that's different than prosecution. Prosecution is to seek redress or punitive measures for someone who has violated a criminal law. And so we have different goals and different responsibilities. That's why if they're dealing with somebody who's made a good faith effort to correct, they have to consider that and all those things. We're bound by the idea that we have to prove mens rea. And we have to prove if somebody's violated the law that they did it on purpose, that this is at least a knowing violation. So the distinctions in our goals are different. And also, we're bound in the criminal courts to have the public know our business. We're supposed to have public trials. We're supposed to have transparency with the public when we're seeking a prosecution. And so we really have totally different goals with totally different rules that apply to us. The other issue here is that the petitioner's interpretation would create absurd results here. You have 8 members of the Texas Ethics Commission. 4 are appointed by the governor, 2 are appointed by the lieutenant governor, and then you have 2 that are appointed by the House of Representatives. And what the petitioner is arguing for is that those 8 people that are handpicked by the executive branch and the legislative branch would have the sole responsibility out of all the state of Texas to decide, and the sole power to decide when a election crime can be prosecuted. And that is basically putting the foxes in charge of the hen house. We have an independent judiciary branch for a reason. If petitioner's argument is correct, then we have become puppets of the executive branch of government. They are able to tell us who we can and cannot prosecute within their own branch of government, including the people that have handpicked them to serve.
But they're required to have people from different parties that they appoint, so that it is a bipartisan decision and has a whole review process. And then again, all it does is it doesn't, it just specifies specific types of election code violations, and then says, okay, once we refer, then the DA has authority to represent the state of Texas.
And I see I've gone red. Would you like me to respond to that? Or?
Judge Keller, is that okay if she responds?
I would say that our authority derives from the Constitution, and that, yes, they are picked from different branches, and there is a procedure there in place, but it's deeply concerning that, you know, instead of having prosecutors from their own counties that are independently deciding these things, it's concerning that a governor gets to handpick, and the governor has sole veto power over the whole board, where he can just throw out and say, I don't like any of the commissioners, but it's concerning that he has sole authority, whatever party he may be in, to handpick his prosecutors. That's our big concern.
Thank you, counsel.
Just like to use a few moments to distinguish some of the points the state has made. Earlier, there was a hypothetical concerning stealing of signs. In this case, obviously that's not the facts in this case, but if in that sort of hypothetical situation, theft is a penal code offense, the district attorney has absolute constitutional authority to prosecute any penal code offense. And similarly, in the state's brief, they mentioned that these, again, I think absurd results would occur if the court followed our position. For example, that they could not prosecute persons involved in child care violations or water pollution violations. That's absolutely not our position. Our position is these are factually and as they were indicted, specifically under 571.061. If they were outside of that, the district attorney has constitutional authority to immediately, upon the ordinary criminal justice process, prosecute those type of offenses. So I don't think that the sky would fall should the court assume our position is correct. I would ask the court to consider its previous case where the court discussed delegation of authority to agencies. And that's all we're asking the court to do, is to say that in this case, that the legislature in its wisdom decided to delegate specific fact-finding authority to the Texas Ethics Commission. There are specific limitations on that delegation. There is a process that's an open process that the TEC must follow, and that is subject to, if an adverse result occurs for a person involved in that process, it's subject to agency judicial review by a court in the county where the case is brought. So I think this is a valid, what they've done in 571 is a valid delegation of agency authority, and it's consistent with the good public policy of the state of Texas for a nonpartisan board to review these type of essentially civil issues.
Counsel, it occurs to me as I'm listening to this and I'm listening to what the arguments the state made, does the failure to go through the referral process, could it result in the defense or the defendant being denied the applicability of a defense? I mean, one of the things is that if they can get a favorable, there's nothing here, but we're still referring it, the defendant doesn't have a chance to raise that defense at trial.
Correct. And the state's point is that my client could have called the TEC, and I will agree that that's a possibility that we can discuss whether that factually occurred or didn't occur. But if the statutory defenses in 571 were to be raised, for example, if we were to get an opinion by TEC, we as the petitioner, in this case, she had no discretion to decide when the district attorney would decide to indict the case. So if at some point she wanted to decide, whenever the first complaint was made to the point of the indictment, if she was to at some point try to obtain that position, certainly now it's too late, at least would be our position, and the state seems to think that at any point we can just run into TEC and have them review this. But at this point, my client's been indicted on 4 cases. So it's not practical, it's not feasible, it wouldn't be, I think, even just fundamentally fair for the court to require going back after an indictment. So I think the fact of the indictment has eviscerated her ability to exercise that defense. Yes.
Are you aware of any court decision anywhere, any state on the federal side, that has ever said in any context that a criminal referral is a prerequisite to a decision to prosecute?
I can't say that, as far as Texas law, I don't believe such a case exists.
Right, I'm trying to figure out whether, if this court were to make such a decision, would we be sort of a huge outlier? I mean, would we be running against what everybody else in the whole world has to say about what a criminal referral is and the impact of an agency authority, a legislature giving an agency the authority to make a criminal referral? What do other jurisdictions have to say about that?
And Judge, I would have to provide supplemental briefing to the court. I've frankly just focused on the history as far as how Texas has addressed it, but I will provide supplemental briefing on that matter.
I appreciate it.
Thank you. Okay, I see my time has expired. Thank you, Your Honor.
Thank you, counsel. The case is submitted. The court will stand in recess.
All rise.